go ahead and get started. I see that there are still some other people joining us, but that'll be okay. We'll at least get started on the introductions as more people join. So good afternoon, everyone. Welcome to Phi Alpha Delta's November speaker series. Very excited about today's speaker and topic. A couple housekeeping matters before Connie introduces today's speaker. First, there will be CLE certificates for this speaker series. They should be emailed to all attendees within the week and possibly as early as tomorrow. So just keep your eyes open for those if you'd like to claim CLE credit in your respective jurisdiction. Q&A. Time permitting, there will be questions and answers at the end. During the presentation, feel free to ask questions in the Zoom chat. The speaker and us will be monitoring that throughout the next hour, and they may be answered during the presentation. So with that, again, welcome everyone, and I will turn it over to Sister Connie to introduce today's speaker.
Hello, everyone. Welcome to the webinar today. Very exciting topic, very interesting. So today we have with us Chris Slottee, who has over 15 years of experience handling complex commercial, corporate, and litigation matters, specifically with Alaska Native corporations. He also served as a vice president and general counsel for an Alaska Native corporation, and he is supremely well-versed in the issues of corporate governance, legal and risk management, government contracting, bid protests, corporate transactions, and mergers and acquisitions. So Chris has a lot of experience to explain a very, very complicated topic. So with that, turn it over to you, Chris. Thank you so much for joining us today.
Absolutely. Thank you, Connie. Thank you, Lindsey. I appreciate the invitation to come speak to everybody today. So today we're going to talk about Alaska Native corporations and the Alaska Native Claims Settlement Act. I'm going to try to describe kind of how did ANCSA come about? What are Native corporations? How are they different from tribes? And how are they different from other corporations? And some of the unique aspects of ANCs and their businesses. So to start off with, I think you're going to hear me talk at various times during this meeting or this presentation about regional corporations and village corporations and different areas of Alaska. So I think it's helpful to start off with kind of an understanding of the broad scope of the Alaska Native community in Alaska Native community. So what we have on the screen right now is kind of a map that you see it's the traditional territories of the Alaska Native cultures. So these are broad regions within the state of Alaska comprised of different groups of Alaska Natives. And as we see later on, these kind of broad regions, not entirely, but generally align with what will be known as the 12 regional corporations. So these are the broad regions. And then in addition to these kind of broad regional regions, there is also approximately over 225 villages in Alaska. And we have a listing of them here as you see them scattered around at the state. And these are all the individual villages and individual tribes. And as we'll talk about later, each of these individual villages eventually became a Native corporation, a village corporation. And many of them are also Alaska Native tribes, which are different than village corporations. So just kind of give a little bit of background on kind of the Alaska Native community and how they're broadly structured as a cultural matter. So the story of ANCSA and the story of Native corporations starts with the purchase of Alaska by United States. In 1867, the United States bought Alaska from Russia pursuant to the Treaty of 1867. What's notable about this treaty is that it was essentially a quit claim of whatever interest Russia had in Alaska to the United States, but it preserved the property rights held by individual property owners, which would therefore also include individual Alaska Natives. So as kind of later litigation brought about, Alaska Natives, as a result of this Treaty of 1867, still retained, in their view, Aboriginal title to most of Alaska. And specifically in the Treaty of 1867, it identified that the uncivilized tribes will be subject to such laws and regulations as the United States may from time to time adopt in regards to Aboriginal tribes of that country. Uncivilized tribes are defined as those Native people who had not abandoned their tribal relations. As the kind of case law showed, developed at this time and later on, being subject to federal Indian law included an obligation by the United States to protect Aboriginal title. So we have that. So Alaska was bought by the United States. The treaty transferring ownership of Alaska to the United States arguably preserved Alaska Natives' individual rights of Alaska Natives to their traditional native land. And then we have the 1884 Organic Act, which was passed by Congress. And it said that the Indians or other persons in Alaska shall not be disturbed in the possession of any lands actually in their use or occupation or now claimed by them, but the terms under which such persons may acquire title to such land is reserved to future legislation by Congress. This is essentially saying that preserving any claim to Aboriginal title by Alaska that Alaska Natives had to Alaska, while deferring the question of how to actually transmit such title, formal title to Alaska Natives to a later action. But again, 1884 Act again confirms, or at least arguably confirmed, that Alaska Natives retained Aboriginal title in Alaska. So this was very important because in 1959, the state of Alaska was admitted. And in 1959, the Statehood Act also required the state to disclaim any right or title to lands to which that are held by any Indians, Eskimos, or Aleuts. So again, the Statehood Act recognizes and confirmed the right of some Alaska Natives to title to their Aboriginal, to their native land. However, at the same time that it is preserving Aboriginal title, the Statehood Act was also authorizing the state to select over 103 million acres from federal land. So now you have this conflict between the state is going out and making land selections of federal land, but you have Alaska Natives who are also claiming that they had title to that land under Aboriginal title. So you had this conflict between Alaska Natives and the state over, can the state select lands that were claimed by Alaska Natives? An example, in 1959, we had the Ninth Circuit ruling that the Tlingit and Haida Indians held most of Southeast Alaska by claims of Aboriginal title. So there was this kind of legal dispute between the state, the federal government, and the Alaska Natives over who could own the land, who actually owned the land, and could the state kind of take that land from Alaska Natives, or do they have to respect the Aboriginal title? And essentially, what it turns out is that the Alaska Natives, could plausibly claim to Aboriginal title about 365 million acres of land in Alaska. And this kind of generated significant litigation, and that continued from the 1950s through the 60s and 70s. So that's kind of the state of land right before the next event, which was the discovery of oil in the North Slope. And that happened in the late 1960s. And this is at the same time that we were having, fuel shortages in America. And this discovery was viewed as a kind of a boon, a natural resource that needed to be developed and extracted. However, the federal government and the state and other private companies had a problem. To be able to transmit the oil from the North Slope of Alaska down to Valdez required construction of a pipeline. And that pipeline would necessarily traverse over land that Alaska Natives claimed title to under Aboriginal title, and would have a plausible claim for trespass if they went ahead and built the pipeline without resolving the land ownership issue. And of course, those trespass damages would be approximately equal to the profits that would have been derived from the oil. So you had this kind of situation was brought to a head where the state and the federal government needed to have this oil developed, but could not develop it without resolving the question of who owned Alaska, who was their Aboriginal title, what claims did the Alaska Natives have. So the Alaska Native Claims Settlement Act was the result of that. It is essentially, or not essentially, it is exactly a settlement agreement between the federal government, the state of Alaska, and the Alaska Natives. It was passed on December 18th, 1971. And as part of the settlement, the federal government receives extinguishment of all Alaska Natives' claims to Aboriginal title. In return, the Alaska Natives received 45.7 million acres of land to be divided between regional and village corporations, $962.5 million in cash, also to be divided between regional and village corporations. And then the state of Alaska, as the third party to the settlement agreement, received the ability to make its selection of 103 million acres from federal land. So what INCSA was an attempt by Congress and President Nixon at the time to chart a new path in addressing federal government relations with tribes. Prior to INCSA, and certainly at the initial stages of the United States, the approach towards Native Americans was to create reservations and to generate reservations and put tribes in charge of reservations. And in the 1960s, though, by that time, the federal government decided that it wanted to try to chart a new path, something that was not based on reservations. And so they, through ANCSA, they converted the communal Aboriginal claims of Alaska Natives, so their claims into owning their own land, owning Native land, into private property, i.e. shares in Alaska Native village and regional corporations. And as we can see here, this kind of quote I have here on the screen is from ANCSA, and you can see it specifically rejects the idea or the issue of establishing new tribes or new reservations in Alaska. It states that the settlement should be accomplished rapidly, with certainty and conformity with the real economic and social needs of natives, without that litigation, with maximum participation by natives in decisions affecting their rights and property, and without establishing any permanent racially defined institution, rights, privileges, or obligations, without creating a reservation system or lengthy wardship or trustee, etc. So what they were trying to do was chart a different way of addressing Alaska Natives, Native Americans, through a method other than the creation of reservations. Now, in looking at the legislative history to ANCSA, we can see that it is, to a degree, a social experiment. It was an attempt by Congress to convert the Alaska Natives from a traditional Native tribe, traditional Native approach, to a more capitalistic ownership culture. And I think as we see here, this quote from Alaska Natives and American Laws, which is citing some testimony given by one of the drafters of ANCSA, where he says that the ANCSA could fairly be described as pointed towards social, individual, and attitudinal changes. Now, I'm thinking that the private corporation matter and the financial experiences matter have to do with attitudinal changes that we're hoping to accomplish, maybe even some cultural ones. So Congress was pretty explicitly trying to reshape Alaska Natives and their culture to be, again, a more capitalistic approach rather than the reservation system and traditional tribal system that was used in the lower 48. And as a result, we have Native corporations, and federal government's relationship with Native corporations is unique. It is unique to Alaska. It is not the same in any. The federal government does not deal with any other Native communities or Native entities in any other way as the manner in which they do in Alaska. And indeed, the refrain from the Supreme Court is that Alaska is the exception, not the rule. So, how are ANCSA? What is the structure of ANCSA? How are Alaska Native corporations structured? As a fundamental matter, Alaska Native corporations are not tribes. They are not tribal governments. They don't have sovereign authority. They don't have sovereign immunity. They are for-profit corporations organized under Alaska state law. They're C corporations for tax purposes. So Alaska Natives, those Alaska Natives, which is individuals who are 1/4 blood quantum or more, who were alive on December 18th, 1971, were issued 100 shares for their village corporation and 100 shares for their regional corporation. Those Native corporations elect boards of directors, they have bylaws and articles of incorporation, they hold annual meetings of their shareholders, and they issue dividends. So ANCs, again, are not tribes, they are corporations and treated, except for some very specific exceptions, treated the same and subject to the same laws as any other corporations. Now, Alaska Native tribes remained in Alaska. There still remain over 200 federally recognized Alaska Native tribes. However, they were sidelined by ANCSA. They did not receive any resources from the federal government pursuant to ANCSA. They received no portion of the $900 million, nor did they receive any of the land. But they still exist. So they don't have any reservations, but they still exist, and they still have sovereign immunity. They still have tribal members, but they don't have any land over which they really have jurisdiction. So they were sidelined as ANCSA. We certainly have seen in the last 20 years a resurgence of some tribes as they attempt to grow and attempt to expand their resources, and some of them are very successful at that. But again, generally, the Native corporations are the primary organizing entity for Alaska Natives and provide the primary economic driver, cultural support, and political kind of representation of Alaska Natives at this point. So I talked a little bit, I mentioned earlier that Alaska Natives alive on December 18th, 1971, issued 100 shares for their village corporation and 100 shares for their regional corporation. So regional corporations, there were 12 of them, well, really 13 of them, but there are 12 now. 12 regional corporations that were established. I have them listed here. And these are based loosely on similar, generally on those same kind of cultural regions that I had shown by map earlier on. And we can see here, here are the kind of the maps of their different regions. So we have Arctic Slope Regional Corporation at the north there on the North Slope, Nana Regional Corporation Northwest, Doyon is the interior, Cook Inland region, for example, that's where Anchorage is located in the Kenai Peninsula. Koniag is the island of Kodiak. Sea Alaska Corp in the bottom right is where Juneau and Southeast Alaska. So these are the 12 regional corporations, and then Aleut Corp, which is the Aleutian Islands. So these are the 12 regional corporations, and they are comprised of shareholders who are living in that entire region. They're generally larger corporations. They're generally bigger than village corporations. They oftentimes have a greater number of employees. In many cases, significantly more assets, and both in terms of value and amount. They generally have larger boards of directors because they, in many cases, have directors elected from each individual village or specific regions. So oftentimes they have boards of directors that are between 12 to 23 people on the board. And they generally have more shareholders than village corporations. For example, Calista Corporation, which is the regional corporation for Western Alaska, as we see on the map here, they have, I think, over 40,000 shareholders at this time. But that can vary quite a bit because they may have 40,000 shareholders. Chugach Alaska Corporation, which is, as you can see in the kind of the middle to the bottom part of this map, I think they have a little north of 1,000. So it really could vary based on the regional corporation and their population base, how many shareholders they have. So there's a lot of variation between the different regional corporations, but in general, they are generally going to be bigger corporations, both in size, revenue, and assets, and also a number of shareholders. So in addition to regional corporations, there were over 200 Alaska Native village corporations created. These were based on the traditional Alaska Native villages. If there were 25 or more Alaska Natives living in a village, that village was eligible to create a village corporation. They are of varying size. Some are very big. For example, Bethel Native Corporation, which is the village corporation from the city of Bethel, has over 1,000 shareholders and is probably about $50 to $60 million of revenue per year. Versus there is a Chulanuik Native Corporation is probably, I think they have at this point through death and through death of shareholders, maybe 17 to 18 shareholders. So it can really vary based on size, based from village corporation to village corporation. Some have gone defunct. Some have been extremely successful. For example, I think Chinigan Village Corporation is north of $1 billion of revenue a year and probably has less than 200 shareholders. So one important thing to note about regional and village corporations is that the regional and village corporations, they don't have a formal relationship. They are separate legal entities. They are not subsidiaries of each other. They are politically and culturally aligned in many cases, but not in all. And sometimes they do compete both culturally or both politically and potentially and also economically. So there's connections there, but they are distinct and entities from each other. Okay, so we're talking about land ownership. As I mentioned before, 45.7 million acres of land was transferred to the Alaska Native corporations, both village and regional corporations. And what essentially happened was that the village corporations were able to select land that was currently owned by the federal government in and around their villages. And they generally had to select contiguous parcels, and they would select them kind of by section. So township and range and in individual sections, they'd make a section by section selection. Now, notably, the village corporations only received surface estate. And for any land that the village corporation received a surface estate, the applicable regional corporation received the subsurface estate. And so what's the difference between surface and subsurface estate? Well, it's kind of what it sounds like, right? The surface estate is the surface of the land, right? You can build buildings on it, etc. The subsurface estate is the right to the minerals, to the oil, to the gas, to the coal, to the gravel in certain cases, to those minerals that are located underneath the ground. That's the subsurface estate that the regional corporation received. So village corporations in general received no subsurface estate, while most regional corporations received very little surface estate, but quite a bit of subsurface estate. I have this note here that there is an obligation by ANCs to transfer land to local cities and municipalities and prior users. It's called 14C of ANCSA. And what it basically said was that, all right, village corporation, you selected all this land around your village, but you're selecting land that is probably already being used by some folks, either by the city or by school or by individual landowners. They have a cabin or they have a house on it, or they're using it for their business. And it's unfair to you kind of be able to take the land out from underneath them. So for those folks who are already living there, using it prior to ANCSA, the village corporations had to, after they made their land selection and after land was conveyed to them by the federal government, they had to turn around and convey portions of that to those people who had previously been using the land. That's called 14C, land conveyances. So there was $962.5 million contributed to what's called the Alaska Native Fund. 50% of that went to the regional corporations, and those 12 that we talked about, and 50% went to the village corporations, the 250 or so. It was intended to serve as startup capital, so they could use it to get incorporated, to hire employees, to start businesses, to manage their lands, et cetera. And certainly there was a wide range of success on use of the funds in terms of some money was completely wasted, some money was used very well. Unfortunately, there was a lot of money spent on lawyers to probably no great end. At the end of the day. And so most of this money, of course, has been expended by now, and village corporations and regional corporations are relying on their economic operations at this point. So as I mentioned before, only those Alaska Natives living on December 18th, 1971 received shares. And this is one area where Alaska Native corporations are very different than any other corporations. Alaska Native corporations cannot issue new shares unless authorized by a majority of the shareholders. Their shares cannot be sold, nor can they be nor can they be alienated or taken or seized by creditors. So basically, there's a restriction on alienability of Alaska Native corporation shares, the intent being to maintain Alaska Native ownership of their corporations. Shares can be gifted, but only to children of the giftor, or their grandchild or their niece or nephew. And if you're gifting them, you can only gift them to Alaska Natives. So if I'm an Alaska Native and I own shares, I can gift them to my children, but only if they're my descendant. I can gift them to a niece or a nephew, but they have to be an Alaska Native or a descendant of Alaska Native. So you could not gift them to a non-Alaska Native or non-descendant. Now, shares can be willed or inherited by anyone, including all non-natives. So again, if someone is an Alaska Native and they have a non-native spouse, they can leave their shares to their non-native spouse. However, those shares, when held by a non-native, are non-voting. They cannot be used those shareholders, if they're not native or a descendant of a native, they cannot vote for the board of directors. They can't vote their shares in any way. Once those shares go back into the ownership of either an Alaska Native or a descendant of Alaska Native, they become voting shares again. So you'll have situations in which regional and village corporations, they'll have 1,000 shareholders, but maybe 10 of them are non-voting shareholders because they're not Alaska Natives. So again, this was an attempt under ANCSA to maintain Alaska Native ownership of their corporations. Now, notably, when ANCSA was passed in 1971, this restriction on the alienability of shares had a 20-year sunset provision. By 1991, the alienation restriction was going to go away by operation of law. And so 1991 and later, Alaska Natives would have been able to sell their shares to anyone they wanted. However, as that date kept on getting closer, there was greater and greater concern that if that happened, that non-natives would come in and buy up the shares to their native corporations, and that the native corporation and their ownership of traditional Alaska Native land would pass to the ownership of outsiders. And so in 1998, what is hopefully called the 1991 amendments, even though they were enacted in 1988, they extended those restrictions on alienability indefinitely. So at this point, the shares are going to be not alienable, cannot be sold, until and unless a native corporation shareholders vote to make their shares alienable, to make them able to be sold. And to date, no native corporation, regional or village, has taken that step. So Alaska Native shares to this date cannot be sold and can only be gifted to Alaska Natives or descendants of Alaska Natives. So corporate governance of Alaska Natives. So they're governed by a board of directors that are elected by the voting shareholders, those shareholders who are Alaska Natives and or descendants of Alaska Natives. Only shareholders and only voting shareholders can serve as members of the board. So you have to be Alaska Native or a descendant to be elected to the board. Directors are generally served staggered terms, generally 3-year terms, and such that some subset of the entire board is elected to a 3-year term at each annual meeting. In Alaska, for Alaska Native corporations, they have annual meetings, and they're often in-person annual meetings, but 95% of all voting for the board of directors is done by proxy. So the Native corporation will send out a proxy solicitation, which is basically a request that a shareholder execute a proxy, appointing generally it's some director who is not running for election to vote their shares. And very often it's a directed proxy, which means that the shareholders will say, all right, I appoint person X to be my proxy, but they don't have discretion how to vote my shares. They must vote them for this specific person. And so that's the most common way in which Alaska Native corporations conduct their annual elections, and that's how almost all votes are cast for elections for boards of directors. Now, normally, when you send out proxy solicitations of this type, you're subject to a whole host of SEC regulations, et cetera, because you're going to have so many shareholders, and the ANCs are worth so much. However, Alaska Native corporations under ANCSA are exempt from federal securities laws. All the federal security laws do not apply to Alaska Native corporations. However, there is some state laws that do apply, and specifically Alaska has statutes and regulations that bar false and misleading proxy solicitations in ANC elections, which means you can't send out a proxy solicitation saying, hey, vote for me because I'm going to be able to sell the Native corporation's assets and give everyone $10,000. That in almost all cases is probably going to be false and misleading and would be an illegal proxy solicitation, and it's not permitted. Now, and also Native corporations over a certain size, which is those ANCs that have more than 500 shareholders and more than $1 million of assets, also have to file their annual reports and their proxy solicitations with the state, so they can be reviewed by the state essentially, and those are public records. So ANCs are exempt from federal securities laws, but still have to follow certain state rules, which is the primary rule is you can't use false and misleading statements. And the state has also imposed certain disclosure obligations, such as Native corporations, when they seek out proxies from their shareholders, they have to disclose how much are the directors paid, who are the top 5 highly compensated employees of the corporation, and how much were they paid, what is the attendance of directors for board of directors meetings, and a couple other disclosure obligations. That's an attempt by the state to require ANCs to provide certain amount of kind of corporate governance information to their shareholders, so their shareholders can arguably make an informed decision in electing the board of directors. So other unique characteristics of Alaska Native corporations. So ANCSA land, which is land that was conveyed to the Native corporation by the federal government pursuant to ANCSA, so those land selections, that 40-some million acres of land, all of that land is protected from adverse possession, property taxes, and seizure by creditors until and unless it is developed. So essentially, if it's leased out to a third party or they start building on it, then it becomes subject to all the standard kind of creditors can claim it. It can be adversely possessed, it be taxed. But until that happens, it is exempt from all of those. Native corporations are also exempt from certain aspects of Title VII of the Civil Rights Act. They are essentially said they are not an employer under Title VII of the Civil Rights Act. So that means they can discriminate in favor of their shareholders when making hiring decisions. Now, I would note that this exemption only applies to the federal Title VII. It does not apply to state law. So while if I'm a Native corporation, I may be exempt from EEOC governance, the state, for example, in Alaska, the State Human Rights Division could take an action against a Native corporation for discriminatory hiring practices. But the federal government, EEOC, could not make a claim because of this exemption from Title VII. Other unique characteristics. So ANCs are structured as corporations, and it's a basic principle of corporate law is that the corporation has to treat all shareholders equally, and that you cannot, for example, issue a dividend to only some shareholders but not other shareholders. And that's really focused on kind of like closely held corporations where you don't want the majority shareholder kind of squeezing out or treating the minority shareholder unfairly. Well, Alaska Native corporations, they're more than just a for-profit corporation. Again, They represent the cultural, political, and social capital of Alaska Natives, and they have a lot of extra obligations and kind of roles to play beyond just an economic profit producing engine. And so ANCSA was amended to permit Native corporations to provide a broad array of benefits to the shareholders and the family members of the shareholders on a basis on other than share basis. So what does this mean? That means that Alaska Native corporations can, for example, provide an elders benefit in the form of, let's say, $200 a month to elders defined as those Alaska Native shareholders who are 65 years or older. So you can provide them $200 a month regardless of the number of shares they have. You could provide youth scholarships to descendants of us shareholders or descendants of Alaska Natives. And so all of these aspects, which would normally be impermissible kind of distributions or unequal dividends under traditional corporate law, are explicitly permitted under ANCSA. Now, that being said, dividends to shareholders are a primary focus of Alaska Native corporations because shareholders will often rely on those dividends as a regular source of income, and a significant percentage of Alaska Natives are at or below the poverty line. And so you will see varying amounts of dividends between $4 a share upwards to $35 a share to potentially $50,000 in the course of a single dividend. So it really kind of varies based on the size and success of the Native corporation. But all Native corporations, to the extent they can, try to issue regular dividends to their shareholders. One other unique aspect about Native corporations is that the value of a Native corporation share and the first $2,000 received from Native corporations don't count when determining whether or not someone is eligible for federal benefits. So, for example, if you're an Alaska Native shareholder and you're on Medicaid, you could receive up to $2,000 from a Native corporation, and that does not count, and it would not make you ineligible for purposes of receiving federal benefits. So this is, again, a recognition that, unfortunately, a significant number of Alaska Natives are below the poverty line and rely on federal government assistance, as well as state assistance. And they don't want to put these Alaska Natives in a position of having to either refuse their dividends from their Native corporation or having those dividends push them out of eligibility for federal benefits. ANCSA also confirmed that Alaska Natives, even though they may be a member of a shareholder but not a member of a tribe, still remain eligible for all federal Indian programs on the same basis as other Native Americans. It's essentially confirming that Alaska Natives are Native Americans and are treated equally and the same by the federal government. And then there's also additional statute that recognizes that the taxpayer's gross income will not include a general welfare grant issued by an Indian tribal government, which includes Alaska Native corporations. So this means that general benefit programs provided by ANC, such as that Elders Benefit Program, would not qualify as gross income because it is a general welfare payment, just as support provided by a tribe to its tribal members would not count as gross income because it is a tribal general welfare payment. So this 26 USC 139E is an example of one of the areas in which Congress has tried to treat Alaska Native corporations the same as Indian tribes in certain respects, even though ANCs, again, don't have sovereign immunity, don't have that kind of governmental role. So we talked a little bit before about how ANCs and shareholders can or that you can inherit an ANC shares in a Native corporation, even if you're not an Alaska Native. And this is because Native corporations can leave their shares to anyone or any entity with a will. And if you don't have a will, then it passes through interstate succession. But notably, Native corporation shares do not go through probate. You don't have to go to court. If you're going to be inheriting Alaska Native shares, you don't go to court to get a confirmation that you're to inherit the shares. Instead, the Native corporation determines who inherits the shares based on affidavits from the decedent's family members. So it's kind of a unique situation in which, again, Alaska Native shares do not go through probate. Alaska law also has a unique rule that if Alaska Native shareholder passes away and they have a living spouse at the time they pass away, 50% of their shares go to the spouse and the remainder goes to the children. So that is a situation in which, particularly if an Alaska Native has married a non-Alaska Native, you can have some of the shares going to non-natives and therefore becoming non-voting shares. Now, I talked a little bit earlier about that you could not issue that only shares were only issued to Alaska Natives who were alive on December 18th, 1971. Well, that meant that if you were Alaska Native and you were born on December 19th, 1971, you didn't get any shares. You'd have to wait to be either gifted or inherit your shares. And so that left a class of folks that are referred to in Alaska as the quote unquote afterborns, which are those Alaska Natives and descendants of Alaska Natives born after December 18th, 1971. And the issue that ANCs are running into is that as their shareholders, their original shareholders pass away and their shares are inherited by their children or their spouse, the share ownership is becoming more and more diffuse. Whereas if you might have had 300 shareholders, each had 100 shares, but now 50 years after ANCSA got passed, you might have 700 shareholders, but everyone might only have, on average, about 10 shares. And at that point, it becomes harder to kind of develop the community and involvement in the Native corporation, because if someone only has 10 shares and they're getting a $5 share dividend, that's $50, right? They may not have much connection to or interest in participating in the corporation or even attending annual meetings, meaning it's harder and harder to have the quorum necessary to elect directors. So what some Native corporations have tried to do in order to kind of foster the continued kind of expansion of the shareholder base and foster more connection to the corporation is approve what's called descendant enrollment, which is go to the shareholders to get approval to issue new shares to either to Alaska Natives who are the children and grandchildren of the original shareholders. And so many times, in almost all cases that they've done this, when they issue those shares, they issue only a life estate interest in their shares, which means that the descendant who is getting these new set of shares, they'll have 100 shares or 50 shares or whatever number it is, but only so long as they're alive. And then once they pass away, their shares go away. They can't be inherited or gifted. So it kind of permits the native corporation to expand their shareholder base, generate more connection, but without creating a whole new class of share that's again going to be diluted out over time. Almost all regional corporations have gone through descendant enrollment, and more village corporations are as well, because again, they're trying to capture or bring in a better connection to the younger generation. And they view that one of the best ways to do that is to issue them new shares so they feel more of a kind of ownership interest / involvement with the Native corporation. So how are Alaska Native corporations similar to other corporations? Well, they have no sovereign immunity. They can sue and be sued. Again, there's no governmental aspect of them. They're classified as C corporations and taxed as such, and they're governed generally by Alaska's Corporations Code. So they're subject to the same rules on notice requirements for board meetings, notice requirements for holding annual meetings, for electing board members, for holding shareholder meetings, etc. So you'll have a significant amount of Native corporations spend a decent amount of time on corporate governance issues and making sure they're complying with the applicable state law, complying with their bylaws, et cetera, just as would any other for-profit corporation. So how big are Native corporations? How big are they? Well, they can be pretty big. ASRC, which is Arctic Slope Regional Corporation, is the regional corporation for the North Slope of Alaska. In 2021, its revenue was $3.8 billion. Bristol Bay Native Corporation in 2022, its revenue was $2.1 million. That's also a regional corporation. Afognak Village Corporation, which is a village corporation for the village of Afognak on the island of Kodiak, its revenue was $650 million in 2022. So these entities can be very, very big. So how do they get there? Kind of two broad aspects: royalty sharing, revenue sharing from natural resource extraction, and government contracting. So revenue extraction. Obviously, Alaska has a ton of oil. Also has a lot of gold, a lot of zinc, a lot of just natural resources that regional corporations largely own because they own the subsurface estate. And so those regional corporations can generate a lot of revenue from those oil leases, from those natural gas leases, from extracting the gold, extracting the zinc, extracting, et cetera, timber sales, et cetera. And Congress recognized that when it established ANCSA, when it established the regional corporations, there was going to be a disparity of resources. To jump back a little bit. So Arctic Slope Regional Corporation, it's on the North Slope. There's a ton of oil up there. It's going to have a ton of natural resource revenue from that. Calista Corporation, which is in Western Alaska, does not have very much oil. It is going to be much more disadvantaged. It's going to be much lesser lesser availability to it of natural resource dollars from natural resource extraction. So as a way to try to kind of equalize the interests of the different regional corporations, they included what's called 7I, Section 7I of ANCSA. Under Section 7I, 70% of a regional corporation's net profit from the sale of natural resources, it's the sale of oil, sale of timber, coal, etc., has to be shared with the other regional corporations. So if I'm Arctic Slope Regional Corporation, you get to keep 30% of your net profit from the sale of oil, and 70% of that net profit gets paid out to all the other regional corporations. The regional so all that from all the regional corporations, that 70% goes into one big pool, then it gets split up amongst the 12. And of that money, of that 7I money that goes to the regional corporations, those regional corporations then have to turn around and give 50% of that money, of that 7I money, to the village corporations in their region. That's 7J of ANCSA. 50% goes to the village corporations, and actually half of that goes to the individual village corporations. The 50% goes to the village corporations and also shareholders in the region that are not also shareholders of a village corporation, called an at-large shareholder. But essentially that 50% gets split up amongst that pool, and each village corporation gets a certain amount of that based on their number of shareholders. So if you're a village corporation and you have a larger number of shareholders, you get a bigger share of 7J revenue. If you have a smaller number of shareholders, you get a lesser share. So, and as an example, NANA, 7I payment to the other regional corporations in 2018 was $217 million. So that's 70% of their net profit was $217 million. And that's largely from the Red Dog mine, which is a very large zinc mine, gold mine in the NANA region. 7J, these 7I and 7J payments, they're a regular source of funds, particularly to the village corporations, and can be between $100,000 to several million dollars a year based on the number of shareholders. And for many of the smaller village corporations, the 7J payment that they receive is by far the biggest kind of revenue source that they have. And they use it to either fund dividends or to fund their corporate operations. So that's one way some ANCs have grown, is both through the natural resource extraction and generating money from that, although they do have to share, as I said, 70% of that, at least on the regional corporation side, with the other ANCs. The other area that ANCs have really taken advantage of is federal government contracting revenue. So this is a chart that shows that in 2021, a little over $11 billion of federal government contracting revenue was received by Alaska Native corporations. So that's just Alaska Native corporations, 12 regional corporations, and 66 village corporations engaged in federal government contracting. And of those entities, they had $11 billion in the aggregate of federal government contracting. Now, very little of that government contracting was in Alaska. By far, the majority of it is in the lower 48 and throughout the world. This other study by the Minneapolis Fed found that those ANCs involved in government contracting own in an aggregate a total of over almost 1,400 different entities, subsidiaries, to perform the different federal government contracting contracts. So ANCs have a very outsized role in federal government contracting. And why is that? It's largely driven by what's called the 8A program, which is a small business administration program. So under the 8A program, it's a program that is designed to direct federal government contracting dollars to small businesses to help them grow to be something other than small businesses. And the federal government's kind of broad-based theory is that the national defense and the national economy is made better if you have a strong small business contracting base. And so therefore they direct between 10 to 15% of federal government contracting dollars to small businesses, is the goal at least. So the SBA program permits, the benefit of the SBA's 8A program is that it permits the government agencies to award sole source awards to small businesses in the program. A sole source award is an award that is made without competition. So you don't issue an RFP, you don't issue a solicitation, you don't have proposals, you just say, you, 8A entity, here's the contract, you don't have to compete for it, we're just going to give it to you. Now, to get into the 8A program, you have to be both economically and socially disadvantaged, and also managed by an economically and socially disadvantaged individual. These are the general rules that apply to almost everybody. And normally, a person can only have one 8A company in their lifetime, and their company can only be in the 8A program for 8 years. Again, the goal here is supposed to be, the 8A program is supposed to help small businesses get started. It's not supposed to be kind of a lifelong government contracting advantage. So you're only in the program for 8 years. And if you're an individual, you can only get a sole source award up to $4 million for services and $7 million for manufacturing. So that's the general rules that apply to everybody, except for native corporations and to a lesser degree, tribes. So for native corporations are deemed to be socially and economically disadvantaged as a matter of law. So they don't need to prove that they're socially or economically disadvantaged. They just automatically are. Notably, tribes are deemed socially disadvantaged, but have to prove economic disadvantage. So that's one distinction between ANCs and tribes. So this permits ANCs easy access to the 8A government contracting program. All they have to do is create a subsidiary, show that the subsidiary is owned by a native corporation. It should be automatically into the 8A program. That's not the only benefit. ANCs can receive sole source awards in the 8A program of up to $100 million per contract. And there's technically no limit on the size of the sole source award if the contracting officer wants to go through what's called the justification and approval process, i.e. you could get a $200 million sole source award. Additionally, ANCs can have non-socially and non-economically disadvantaged individuals run and operate their programs. So that you have a lot of ANCs who have lower 48 government contracting programs that are staffed entirely by non-Alaska Natives or non-Native Americans. Notably, ANCs can also have multiple 8A companies. Whereas I noted before, if you're an individual, you only have a one-time shot. You have once in your lifetime and you don't get it again. ANCs can have as many as they want, essentially, 8A programs. And this is the real key. So if I'm an individual and I own two companies, Company A and Company B, and I go to the SBA and I say, hey, I want to take Company A into the small business 8A program. SBA say, okay, fine. Let's say I assume I'm economically and socially disadvantaged. Well, in determining whether or not I'm small, because I have to be a small business, they're going to say, well, that's going to be based in large generally on how much total average revenue you have. And when calculating my revenue, they're going to look at the revenue of both Company A that I own, but also Company B that I own, because I'm affiliated between the two of them. I have common ownership. So you're going to aggregate all the revenue from both of them to say, as a total, are they small? And only if, as a kind of aggregate total, if they're small, are you eligible to get in the 8A program? Well, the kind of the size standards, the top end of the revenue that you can have in order to be eligible for the 8A program, it's varies depending on the nature of the work, but it could be between $15 million up to maybe $48 million of average annual revenue. So that's kind of limited. So you look back at ASRC as a $3.8 billion company, it has a ton of 8A companies. Well, how is that possible? Well, it's possible because under ANCSA, native corporation subsidiaries are not deemed affiliated with their sister subsidiaries because of common ownership, management, or shared services. So that means that a company like ASRC can have 10 different 8A companies, and each individual subsidiary will be determined to be whether or not it's small based on just that revenue of that individual subsidiary. They ignore the family of companies. And that's a unique advantage available only to ANCs and tribes and Native Hawaiian organizations. So as a result of all this, ANCs have been able to have many 8A companies doing large amounts of federal government contracting. Again, as that slide showed before, a total of $11 billion was done in federal government contracting by ANCs in 2021. So that's been a real big driver of Alaska Native Corporation growth and the revenue that they're generating. So what are the issues that ANCs are confronting? Well, it's economic development for shareholders and descendants. ASRC is a very large company that, see that $3.8 billion of revenue, but of course they also have a lot of expenses and they have a lot of land to manage. They have a lot of employees to manage. And while they certainly send out significant dividends to their shareholders, many Alaska Natives are still living below the poverty line. It's even harder for a corporation like Slottee Corporation. Slottee Corporation may be between $500 to $700 million of revenue, but it also has about 40,000 shareholders. It's really difficult for the regional corporation to provide sufficient economic support to its shareholders to lift them out of poverty. So what ANCs are focusing on is not necessarily on individual dividends, but rather trying to develop economic development within their region or within their village, either in the oil industry, fishing industry, tourism, just trying to find some way to bring jobs home to Alaska, bring jobs into the villages so that the shareholders can still live in the village and still have the ability to make some money and have a job. So that's a very primary focus of ANCs. is to try to develop that economic development within the regions, within the villages. The other issue is the one we talked about, descendant enrollment, is it bringing on afterborns. There's a lot of benefits in doing so. There are some downsides. They reduce the amount of dividends that each individual shareholder receive, because you'll have many more shareholders that you have to split, have to share kind of a limited pool of money. It also decreases the voting power of the original shareholders. So it's definitely a very a very significant issue that Alaska Native corporations and their shareholders take very seriously and take a very long time to work its way through. Many Alaska Native corporations and villages are dealing with climate change because either the permafrost is starting to melt and that's impacting the villages. Some villages have already had to move once or twice, like move the entire village, because the locations where their traditional locations are no longer viable to have the village. There are a variety of lawsuits that have and are challenging Native corporations' role and relationship with the federal government. Chehalis was a very significant one. It was a fight over CARES Act money and whether or not Native corporations received CARES Act funds. That ultimately was won by village corporations. Right now, the Tlingit and Haida Central Council is trying to move land into trust in Juneau, essentially to create a version of a reservation in Juneau. The state of Alaska is challenging that, arguing that ANCSA prohibits the creation of reservations within Alaska. Burkine, which was recently decided by the Supreme Court, but not entirely. So Burkine was an issue over kind of placement preference for under the Indian Child Welfare Act, which essentially there's a portion of the Indian Child Welfare Act that states that a native child's placement within Alaska with a native family is going to be kind of preferred or have priority over placement with a non-native family. And there was a challenge on due process considerations on that. And the due process challenge was the most concerning one because it was arguing that this was a racial discrimination, discriminating against non-natives in favor of natives. The Supreme Court did not take it up, did not decide it one way or another, but rather sent it back down and said that the plaintiffs in this case did not have the standing to make that due process challenge. So that due process challenge may show up again and raise a very significant issue. And then there's Maverick Gaming, which is an issue over can states such as Washington and Oregon issue or only permit Native Americans to have gaming and prohibit non-Native Americans to have gaming, again, on a racial discrimination type of claim. And then the final case here I reference here is Ultima. This is one that has caught a lot of attraction by Alaska Native corporations. It was a challenge to the 8A program. It was not a direct challenge to Alaska Native Corporation or tribal participation in the 8A program, but the briefing has certainly raised the possibility that some litigants in the future will try to argue that the benefits given to Alaska Native corporations in the 8A program is based on a racial classification and therefore subject to scrutiny as opposed to a political classification, which has been the traditional analysis and therefore subject to a rational basis review. And I apologize for kind of skipping through those last ones right away. I know we're running out of time, and I certainly wanted to give time for a Q&A. So that was a lot of information I know over a very short period of time, but I appreciate everybody's patience, and I'm happy to answer any questions that people might have, either in the chat or any other way.
Thank you, Chris. That was wonderful. A lot of information, a lot of very interesting information. And as you can see, ANCs and Alaska in itself is very complicated. Does anybody have any questions, comments, thoughts, ideas, policy ideas? Because if not, I can get the question started. Okay, that's a no. That's fine. I guess one of the questions that I had was thinking about, oh wait, Victor has a question. Yay. Go ahead, Victor. We'll wait for you to finish typing it out. Lindsey is asking if he's able to speak. I don't know.
Well, Victor was kind enough to type it. And actually, we have another question from Elizabeth as well. So I will try to figure out how to allow the attendees to speak while you look at those.
So Victor asked if the federal government pays the fire suppression cost to the villages, or do the villages or the corporations cover that themselves?
I mean, it would depend on the context, but for the village corporations, and the regional corporations who own the timberlands, right, they would be responsible for the timber management. They may be able to get grants or money from the federal or state government because they recognize the public safety issue, but in general, they're private landowners And so they would only be eligible to the extent other private landowners would be eligible for that type of financial assistance.
Great, thank you. It looks like Elizabeth left a comment, said it was very enlightening, and big thank you to you. She has a friend who is Alaska Native, and she tries to explain these things to her, and you did a great job of summarizing everything up so it's easy to understand and easy to digest, which is awesome. Does anybody else have any more questions? Well, I have a question. So since you just mentioned Maverick Gaming, one of my questions is, can ANCs or even the villages conduct gaming?
No, because so native corporations, they're not sovereign, right? So when they own land, they own it in fee simple. It's not exempt from zoning. It's not exempt from state law. So no, Alaska does not permit gaming. So native corporation lands cannot be used for casinos or other type of gaming. Now tribes, what the Tlingit and Haida is trying to do is create essentially a reservation. And the theory is we expect that if they're successful in doing so, that they may try to establish some type of gaming in the future. We don't know that for a fact. But that's more of a 5 to 10 year issue that would rise because state of Alaska does not have any laws permitting gaming. There's no currently gaming in Alaska other than pull tabs. So as of right now, no, it cannot use native corporation land or tribal land for gaming.
So Victor asked if the Alaskan pipeline pays a royalty fee to all the corporations.
I think they have an easement, so I think they probably make payments on that. But really, where the funds come from is a lot of the oil that's being pulled out is they pay royalties to ASRC and other ANCs that may have an ownership interest in that oil, and then that money gets distributed out amongst all the village corporations under 7I.
And it looks like we have a comment from a gentleman named Aaron. I don't want to ruin your last name, but who is also an Alaska Native and a shareholder. And he would love to speak more with you and chat with you. I'll let you two correspond privately so that way you guys can have a chance to talk with each other. And this is the great thing about these webinars, is making these types of connections with people.
Yes, Aaron, feel free to reach out to me. I'm happy to set up a time to talk. Or whenever you're back in Alaska, we can get together for coffee or whatever. But yeah, just don't hesitate to reach out. Happy to have a discussion.
Does anybody else have any other questions?
Connie, we do have one question. Gabriel Rancifer in the Q&A box. Are you able to see that one?
Yes. So there's a question about eminent domain. So a big thing on a lot of Native entities' minds is ensuring a place at the table with developments in CCS. A big point of interest is the CO2 pipeline. Since ANCs are not tribes, can their land still be acquired through eminent domain?
Yes. Yep, that's fee simple. So while they can't be taken by adverse possession or grabbed by creditors, there's nothing prevented a state or a local town or city from exercising their power of eminent domain. They'd have to pay fair compensation, but yes, they could take ANC lands for that. And I guess in question to Victor, there's still a very significant military presence in Alaska. There's the Joint Base Elmendorf in Anchorage. There's Eielson in Fairbanks. So those are two of the more significant, military installations. There's a variety of ones else there. There's also a huge amount of environmental contamination left behind by old military installations. There, for example, on the Aleutian Chain, I think it was on the island of Adak, the Navy just kind of left and didn't do any cleanup, just left everything behind it. So a significant amount of work that a lot of village corporations and regional corporations do is actually work for the Army Corps of Engineers, for the Navy, et cetera, to clean up the contamination left behind by the military. I'm not sure. I know, Galena is still there for sure, the village is, but I'm not sure if they have an Air Force site there.
I've also been to the Coast Guard base on Kodiak, which was a lot of fun.
And that's a massive Coast Guard base too.
It's huge. We were lucky. We got to stay there. And if any of you can Google, you'll see Senator Murkowski actually did visit the island with the abandoned base. So it's very interesting stuff. And I think that's about all the time we have, right, Lindsey? I know everybody's super busy, and I'm sure everybody's hungry and wants to get moving with their day. So a big thank you to Chris for presenting today. Such a wonderful job. Learned even more about a very complicated subject and more about Alaska, which is always so much fun. And if you folks are interested in more webinars like this, please let us know. And we're happy to do more, especially when it comes to trying to understand not only the complications of federal Indian law, but also all these little nuances, such as like Alaska Native corporations or Native Hawaiian organizations. Very, very complicated stuff. So please feel free to reach out. You've got Lindsey, you've got Aaron, you've got Chris, and you've got me. So thank you so much and have a wonderful day.
Thank you, everybody.